Hi, this is Jen Rubin, editor-in-chief of The Contrarian. I'm delighted to finally have on our program someone who I've communicated with over the years because he is a great authority on voting rights, and that is Rick Hasen from UCLA Law School. Welcome, Rick.
It's great to be with you.
It is terrific to meet you in person after all those emails back and forth over the years. So let's take a step back and talk about the state of voting rights, which is a far cry from where we were, say, in the year 2000, when we had a vibrant pre-clearance system under Section 5 of the Voting Rights Act. We had all kinds of plaintiffs who could bring cases under Section 2. Section 5 was essentially eviscerated in Shelby County. Where are we with Section 2 and this case that the Supreme Court pushed over to the next term from Louisiana?
Right. So the two big pillars of the Voting Rights Act were the preclearance rules, which the Supreme Court put on hold, at least pending any further congressional action, if not forever, in 2013. And the other one is Section 2. Section 2, when it was initially part of the Voting Rights Act in 1965, didn't do more than really restate the 15th Amendment that says you can't have race discrimination in voting. But in 1982, in response to some Supreme Court rulings that read the Constitution pretty narrowly, Congress passed a law that said in Section 2 that minority voters should have the same rights as other voters to participate in the political process and to elect representatives of their choice. That's like some technical language. The Supreme Court, since the mid-1980s, in a case called Jingles versus Thornburg, read it to say basically when whites and minority voters prefer different candidates, that's called racially polarized voting, and the minority group is large enough and living in a close enough area that you could actually draw a single member district where they'd be able to elect a candidate of their choice, whether we're talking about Congress or a state legislature or even a local body like a city council, then there's a chance, more complicated stuff, but there's a chance that a court would order the drawing of one of these districts. And so things have been chugging along ever since. The court, over the last decade, has chipped away at Section 2, made it marginally harder to bring those suits. But in 2023, in a case out of Alabama called Allen versus Milligan, the court barely on a 5-4 vote upheld this same Jingles framework of allowing minority voters to get their districts. And in this way, in the Milligan case, Alabama had to create a second black majority congressional district. But in that case, Justice Kavanaugh separately concurred, and he said, hey, Alabama didn't really present this argument in full, so I'm not going to address it now, but I'd like to hear in some future case about whether maybe time's up for Section 2. Maybe it's no longer constitutional to have race-based remedies in Section 2, kind of parallel to what the court had done before Kavanaugh was on it in the Shelby County case in 2013. Okay, fast forward to last year, the Supreme Court heard a case out of Louisiana called Louisiana versus Calais. In an earlier case, it had been ruled by the courts that Louisiana also had to create an additional black majority congressional district. This was a follow-on lawsuit to that by a group of, quote, non-black voters who said that they thought that it was a racial gerrymander, violating the Equal Protection Clause of the Constitution. This area of the law is very complicated, but basically the first step in this racial gerrymandering question is to decide whether race or party predominated in the drawing of the lines. Alabama was forced to draw the second district, but they drew it in a certain way to protect Mike Johnson, the Speaker of the House. And the question is, was it really about race or really about party? I think that's a nonsensical question, but we'll put that to a side. So we thought we were going to get another one of a series of cases at the end of June where the Supreme Court was going to tell us how you can tell whether it's race or party in a state where most whites prefer the Republican Party and most blacks prefer the Democratic Party. So disentangling these two is basically impossible. But then we got this weird order at the end of the term that said, we're going to hear re-argument of the case, but we're not going to tell you yet what it's about. And then on Friday, August 1st, after 5 p.m. on the East Coast, a great time to bury news, the Supreme Court put out this cryptic additional briefing order that essentially puts Section 2's constitutionality on the block. The way it did it, we can talk about if you're interested, but basically the bottom line is, in the second part of that racial gerrymandering inquiry, if race predominates, the question is there a compelling reason to make race predominate? And one compelling reason could be compliance with the Voting Rights Act. And now the justices seem to be signaling that maybe if Section 2 actually requires drawing a race-conscious district, it could itself be unconstitutional. And so that second pillar of the Voting Rights Act could fall at the end of the next term, which is probably going to be June of 2026.
Now, in her dissent in Shelby County, Justice Ruth Bader Ginsburg had the famous line that you don't throw away your umbrella in a thunderstorm because you're not getting wet. After Shelby, we saw a whole series of laws at the state level that chipped away at voting rights, that made it harder for minorities to vote. The Supreme Court now says, what, things are better? That looking at Section 2, now we don't need it? Is there no recognition of what has happened since Shelby County? They just kind of ignore all of that?
Well, that's a great question. I think there are a few answers. Number one, Section 2 was never about not making things worse. It was about making things better. And so it's asking a different question. I think if you go back and you look at, say, the disparity in voter turnout between whites and blacks, you will see that the turnout gap has gotten larger, especially in the states that used to be covered by Shelby County. So I think Justice Ginsburg's prediction was right. But
Yeah.
we've seen voter suppression laws, not just in those prior formerly covered states, but also around the country.
Yeah.
And Section 2, remember that language is very general, less opportunity than others to participate in the political process. And in a case in 2021 called Brnovich versus Democratic National Committee, the Supreme Court for the first time addressed the question, well, what does Section 2 mean, not in the redistricting context, but in the context of what we call vote denial cases, cases where it makes it harder to, a state makes it harder to register or to vote. And the Brnovich decision, written by Justice Alito, is one of the all-time worst voting rights decisions. I think it mangles the statute, it mangles the history, and it essentially makes it impossible or extremely difficult to bring Section 2 suits outside the context of redistricting. In fact, for an article I recently wrote in the Yale Law Journal, I looked to find any successful lawsuits post-Brnovich making a Section 2 vote denial claim, and there's not a single one. Not a single one in the few years since then. You'd think that there'd be at least one, but what Justice Alito managed to do was render Section 2 a dead letter outside of redistricting without actually saying he's overruling the case. And I could see, especially this is kind of a John Roberts special, there are ways that you could rewrite Section 2, mangle Section 2's meaning in order to make it look like you're not actually overruling it, but in fact, that's what you're doing.
This is nothing less than a major wrecking ball through the entire premise of voting rights. Congress, signed by presidents of both parties, have repeatedly passed the Voting Rights Act. And now the court says there's not really a problem and intervenes to strike down a law that has just celebrated its 60th anniversary, if that's what it's going to do. This seems to be a monumental overreach by the court. It is as if they have declared there is no voter discrimination in the country anymore. Our problems are solved. It is positively Trumpian. And one wonders whether they are pursuing a legal analysis or a political analysis. How do you read what they're doing, which is so at odds with even the recent history since Shelby County, let alone, decades and decades of accumulated history, not only, as you put it, in the original Section 5 states, but at the country at large?
Well, if you go back and you look at the 14th and 15th Amendments, these were amendments that were passed after the Civil War, and they were passed to protect newly freed slaves. In fact, the other amendment there was the 13th Amendment, which barred slavery. And in both the 14th Amendment in Section 5 and in the 15th Amendment in Section 2, it says that Congress has the power to enforce this amendment by appropriate legislation. That is, and Justice Ginsburg wrote this in her Shelby County dissent, Congress has been given the ball, basically. It's the one that's supposed to drive protection of minority voters. It's the one that's supposed to enforce these provisions. And in fact, we know the original public meaning of the 14th, 15th Amendment was race conscious. That is, Congress passed laws specifying race in order to protect minority voters. So if you're looking at the original text, the original public meaning, which is what originalists, conservative originalists on the court say they're going to do, the answer must be that that the 14th and 15th Amendments allow for race-conscious remedies, and especially in the area of voting, I would say, given that the 15th Amendment is targeted at preventing race discrimination in voting. What
Right.
the Supreme Court has done is it's denuded Congress of this power. It has treating Congress like any litigant that has to come before the court and present enough evidence to convince the court independently. The theory behind saying that Section 2 could be unconstitutional, which is what may be up for grabs in the Louisiana case, is a theory of a colorblind constitution. That
Right.
all the Equal Protection Clause says, you can't have any race conscious anything, even if it is to remedy past discrimination. To me, that's turning these amendments on their head. It's a perversity. And, to issue this order, they issued it on Friday at 5, and I said they were trying to bury it. Maybe they didn't want to issue it on Monday at 9, because then it would be coming on the exact 60th anniversary of the Voting Rights Act. Time's up. They said that in Shelby County as to one part of the Voting Rights Act. They seem to be saying it now. And I had a recent piece in Slate where I say the upshot of all of this is that we may get a major ruling in the middle of the midterm election season that I think could spur civil rights protests, maybe could even spur a civil rights movement, because you have a Supreme Court that's not only neutral, not only not neutral on voting rights, but positively hostile. This is the most
Absolutely.
anti-voter court we've had since before the 1960s.
And this is one of many examples in which I argue that the court is no longer behaving like a court. And in fact, we need major structural reform. It is not just simply issuing decisions that Rick and Jen disagree with, but going far beyond its mandate, far beyond the if you will, the original intent of the framers and the original intent of the post-Civil War amendments. And this is really a Supreme Court entirely out of control. But of course, this race neutral notion is straight out of the Republican handbook. That's their philosophy. And now it's been contorted and comes back to us in the form of jurisprudence, which is contrary to our history. I want to go back to something that you mentioned and which now is very relevant in this fight over Texas redistricting. And that is this notion that you can gerrymander for political reasons, but not racial reasons. First of all, that decision allowing political gerrymandering opened up the floodgate for what we are seeing now. Texas would not be doing this, presumably, if they said no. The other problem is, how do you disentangle these two things? African Americans, 90% or so, often vote for Democrats, and whites, perhaps not in as great as number, but overwhelming, particularly in the South, vote for Republicans. So are we just like making up, angels on the head of a pin here? How do you disentangle these two things?
Well, first, I think you're right that the Supreme Court's 2019 decision in Rucho versus Common Cause, which said that there are no standards that federal courts can apply to determine when partisanship is taken into account too much. That kind of a political question doctrine for those lawyers in the audience, saying the political question doctrine applies here. That was a change in the law. Back in the 1980s, in a case called Bandermer, the Supreme Court said there could be claims under the Equal Protection Clause for partisan gerrymandering. And then it took the court decades to try to work out if there was such a claim. And Justice Kennedy kept the issue open for a decade and a half. And then the court just gave up after Kennedy retired and said, no partisan gerrymandering claims. That's a green light. That's why you see Republicans in Texas standing up and saying, we're doing a partisan gerrymander. We've seen this in North Carolina as well. And the reason they're proclaiming it loudly, well, not necessarily that they're proud of it, although maybe they are, but because they want to somehow negate the notion that they might be making race the predominant factor, because that would be a racial gerrymander in violation of the Equal Protection Clause, as the Supreme Court has understood it since the 1993 case of Shaw versus Reno. I've been consistently critical of those cases. I've been critical of those cases when they were used by conservatives. I'm critical of those cases now when they're used by liberals as a way of trying to get kind of Voting Rights Act principles in through the back door. The idea that you could separate race and party and figure out which factor predominates in places where those two factors significantly overlap is impossible. Political scientists call this conjoined polarization. They're like a conjoined twin. Race and party are so connected. So when Texas is going to draw these new districts potentially, and they're going to stick it to the Democrats, they're going to hurt Latino voters and Black voters in the state of Texas. And so
Absolutely.
now, if Supreme Court gets rid of Section 2 of the Voting Rights Act or whittles it down to be basically nothing as applied to redistricting, then those racial gerrymandering claims will be much harder to bring too, because states will be able to rely just on party data. They won't have to be race conscious to comply with the Voting Rights Act. And we're going to see even more egregious partisan gerrymanders come after the 2030 census, come the 2030 round of redistricting. Now, there is someone who can fix this, and it's not the Supreme Court because they're not going to. It's Congress.
Congress, yes.
In Article 1, Section 4 of the Constitution, it says the states get to make the laws for congressional elections, but the Congress can make or alter state rules at any time. And so Congress already makes rules about congressional elections. For example, we elect all of our members from single member districts, as opposed to having multi-member districts where, say, a bunch of more people are electing 3 or 4 members of Congress. They used to have that in some states before, I think it was 1842. Congress passed this law and said, no, got to have single member districts only. So Congress could come in tomorrow. They could say, this is what we mean by partisan gerrymandering. You can't do it. Or they could say, every state needs to use an independent commission, and here's how that would work. Or they could say, we're going to use proportional representation. Like, they could say a lot of things. I don't expect any of those things to happen, especially as Republicans control Congress and Trump has directed maximum warfare against the Democrats, to take a recent quote from the New York Times. That is something that's in the background. And Democrats tried to pass some redistricting reform back when they controlled both houses of Congress, but there were a couple of Democratic senators who were not willing to blow up the filibuster to protect democracy. It's the same reason that we didn't see a renewal of the Voting Rights Act and the John Lewis Voting Rights Advancement Act, which I know has been reintroduced recently.
Exactly. Now, this notion that you can redistrict on politics, but not on race, also runs counter to, obviously, the whole conception of the amendment to Section 2, which said that people are allowed, a minority group is allowed to pick their people. So basically, they are going hammer and tongs through the intent of this legislation, through the intent and the language of the post-civil rights movements, to create something that is going to give hugely disproportionate weight to whites, to states that have, frankly, more easily gerrymandered districts, as opposed to ones that have gerrymandering throughout. It's really an evisceration, and I don't mean to exaggerate, but it's really an evisceration of the fundamental principle. Do we have one man, one vote in this country anymore or not? I don't see what's left of, Baker versus Carr, the seminal voting rights decision. Where are we headed with this?
Well, you mentioned those one person, one vote cases. Those came in the 1960s, in the one period in U.S. history, about an 8-year period of the Warren Court, where the court led on voting rights. It protected the right to vote. It said you had to have equally weighted votes. That's the one person, one vote rule. I think that those cases could potentially be on the chopping block. Back in the 1940s, in California, where I live, for example, small counties had much more power in the state legislature than large counties, because if you elect members to your state legislature by county, one county, one vote, or something like that, you disproportionately favor rural interests. There was an attempt to push back on the one person, one vote rules in a case in the last decade called Evanwell. The court's not quite there yet, but as they take down all of these statutes and legal doctrines that had required certain kinds of fairness in the political process, I don't know what's coming next. And I really do fear that the Supreme Court could take us back to the 1950s, to take us back to the 1920s. Remember, the Supreme Court back in 1874 said that the Constitution didn't protect women's right to vote, and it took 40 years, took till 1920 to get passage of the 19th Amendment. Struggles for voting rights are hard, but when you look over history at where the power has been to expand voting rights, it's typically not been in the courts. It's been through the people, it's been through the Congress, through passing constitutional amendments. That's why I wrote a book called A Real Right to Vote, calling for a constitutional amendment guaranteeing the right to vote. I think
Absolutely.
we have to start thinking more proactively and go state by state. It's not going to be easy. The one thing that gives me a little hope in this area is that as the composition of the political parties is changing, as the Republicans are drawing more on poor working class voters, it's not going to be in their interest to engage in voter suppression. And maybe there's going to be a time when both parties are going to be competing for all the voters, and there'll be an opening to actually try to push through some kind of strong voting rights amendment that could, it's hard with a hostile Supreme Court no matter what the Constitution says, but it would be a lot harder if we had a successful movement to amend the right to vote in this country.
Well, I think Texas is a little peek into the future of what we're looking at. And then we combine that with these ridiculous abusive uses of the FBI and other kind of threats to these lawmakers. And we're really down the looking glass. Thank you so much, Rick, for helping to clarify where we're at, which is not a good place. And we will look forward to coming back. For our contrarians, I could not agree more with Rick. The situation is not going to be saved by the Supreme Court. It's going to be saved by political pressure, first in Texas, then in the elections. And it's going to take a Democratic Party that is willing to do some surgery on the filibuster in order to get real protection for fundamental freedoms and fundamental voting rights. So we will continue to encourage that movement. And thanks so much for joining us, Rick. It's been a pleasure.
Thank you so much.